An application for bail is a fundamental right. Article 50 envisages the breach of a right and is applicable where that right has been violated or threatened with a violation. An application is made in the prescribed form under the Human Rights Enforcement Act, under the regulations made thereunder, by notes of motion. Such an application would be for redress where appropriate, or even compensation where rights have been violated or threatened with violation. In the premises, we find that Section 16 of the Human Rights Enforcement Act does not apply to an ordinary application for the grant of bail or the decision arising from it. It only applies to applications for enforcement of fundamental rights and freedoms as envisaged under Article 50 of the Constitution, as well as provided for under the Human Rights Enforcement Act. In the premises, we sustain the preliminary objection that this court lacks jurisdiction to hear the appeal. Although we have found this appeal incompetent, we are concerned about some of the complaints raised by the appellants. They stated that they have been on remand for 9 months without trial, that they have filed 4 applications for bail and only 2 have been concluded. They contend that no reasons have been given to explain why the other 2 applications have not been fixed or heard. The appellants are members of parliament who have civic duties and are representatives of the people. Thus, their fate should not be in doubt. At the hearing of this appeal, the representatives of the DPP stated that they were ready to prosecute the appellants. Therefore, it is incumbent upon the High Court to ensure that the trial of the appellants begins and is expeditiously concluded so as to meet their human and constitutional rights. We therefore direct the registrar of this court to ensure that all files in respect of the appellants are placed before the principal judge to ensure for the trial of the appellants to begin and be expeditiously concluded. That said, the appeal before us is incompetent and we accordingly strike it out with no order as to costs. We so order.
Is extremely dangerous for all of you Ugandans out there. It means that the High Court, once it refuses to give you bail, you have nowhere to go. You have nowhere to go. And General Museveni has spoken about appointing cadre judges so many times. The reason why we want to always to have opportunities to go to the Court of Appeal, to go to the Constitutional Court, to the Supreme Court, is because maybe you want to get a decision from a panel of 3 people. Maybe you can find sobriety there. If it is a Court of Appeal, for example, if it's the Constitutional Court, 5 judges, if it is the Supreme Court, 7 or even more, so that you can at least get justice when you go to before those courts of law. But now what court has said, you can imagine, all of you Ugandans know that what has been going on. These were given bail by one court, asked to pay 20 million shillings, which they paid. They were immediately arrested, charged with some, an extra bogus charge, and now they've spent 9 months in detention. That is what it means for you, a Ugandan who's out there, that once the High Court declines to grant you bail, you have nowhere to run, which we think is fundamentally wrong.
This is a court of justice. This is a court which we thought that if we run here, they can actually look at that decision and review or revise the bail refusal. So it is really very absurd. And as lawyers, we are going to come to the Constitutional Court for interpretation of that article that grants the right to bail, because we look at it as liberty being restrained, yet the Constitution guarantees the right to liberty and the presumption of innocence.